We're going to talk about in Chapter 4, privacy, technology, surveillance, and freedom. Employers are justifiably concerned about threats to and in the workplace, such as theft of property, breaches of data security, identity theft, viewing of pornography, inappropriate and/or offensive behavior, violence, drug use, and others. They seek to minimize these risks, and that often requires monitoring employees at work. Employers might also be concerned about the productivity loss resulting from employees using office technology for personal matters while on the job. At the same time, however, organizations must balance the valid business interests of the company with the employee's reasonable expectation of privacy. Magnifying ethical and legal questions in the area of privacy is the availability of new technology that lets employers track all employee internet, email, social media, and telephone use. Telematics is a word coined from a combination of telecommunications and informatics. It is technology that transmits data from remote sensors to computers for analysis. Employers, again, are increasingly using telematics to screen everything from email to cell phone use to internet browsing to the exact physical location of their employees and every move they make. Monitored workstations, cameras, microphones, and other electronic monitoring devices permit these employers to oversee virtually every aspect of the employee's at-work behavior. Technology also allows employers to monitor every aspect of computer use by employees, such as downloads of software and documents, internet use, image displayed, time a computer has been idle, and the number of keystrokes per hour words typed, and the content of emails. Surveillance at work. In the private sector, privacy law is determined by a variety of federal and state statutes and by common law of torts. Employees may claim that electronic monitoring amounts to intrusion, a variation of the tort of invasion of privacy. And most courts consider two factors: the obnoxiousness of the means used to intrude, that is, whether it is deviating from the normal accepted means of discovering the relevant information, and the reason for intruding. The 1968 Federal Wiretap Law, as amended by the Electronic Communications Privacy Act of 1986, making it illegal to intercept, disclose, or accept messages without authorization, would appear to protect workers from electronic eavesdropping, but there are a number of exceptions to the ECPA. There is no protection for communications that are readily accessible to the general public, such as public chat room exchanges. The law does not apply to the extent that employees give consent to monitoring, which would seem to eliminate ECPA coverage in the many workplaces where people are warned that their communications are not private. The ECPA, which you will learn about, also allows employers to listen in on communications made in the ordinary course of business. In general, it is legal for a company to monitor the use of its own property, including but not limited to computers, laptops, and cell phones. According to the ECPA, an employer-provided computer system is the property of the employer, and when the employer provides employees with a laptop they can take home, it likely violates no laws when it monitors everything employees do with the computer, whether business-related or personal. The same is true of an employer-provided cell phone or tablet, and always true when an employer gives employees notice of a written policy regarding electronic monitoring of equipment supplied by the company. Generally, the same is not true of equipment owned by the employee, such as personal cell phone use. However, an important distinction is based on the issue of consent. The consent provision in the ECPA is not limited to business communications only. Therefore, a company might be able to assert the right to monitor personal electronic communications if it can show employee consent. Another consideration is whose email server is being used. The ECPA and some state laws generally make it illegal for employers to intercept private emails by using an employee's personal logon, user ID, password information. Although the ECPA and the National Labor Relations Act are both federal laws, individual states are free to pass laws that impose greater limitations, and several states have done so. Some require employers to provide employees advance written notice that specifies the types of methods of monitoring to which they will be subject to. Examples of state laws creating some degree of protection for workers include California and Pennsylvania, that both require consent of both parties before a communication can be monitored or recorded. Many employees generally are not familiar with the specific details of the law. They may feel offended by monitoring, especially their own equipment. Companies must also consider the effect of workplace morale if everyone feels spied on, and the risk that some high-performing employees may decide to look elsewhere for career opportunities. Employers should develop clear, specific, and reasonable monitoring policies. The policy should limit monitoring to that which is directly work-related. For example, if a company is concerned about productivity and the goal of monitoring is to keep tabs on employee performance, then neither keystroke logging nor screenshot recording is necessary. Software designed to show idle time or personal internet use would be more helpful in identifying wasted time, which is the ultimate goal. Employers should always remember their business goals when monitoring employees. It is not a matter of treating employees ethical. It's not only a matter of treating employees ethical. It also makes good business sense to ensure that monitoring pertains only to business matters and does not necessarily intrude into the privacy of employees. Perhaps most importantly, in the interest of fairness, the monitoring policy must be communicated to the employees. Alan Weston, who was a Columbia University professor emeritus, a corporate consultant on privacy issues, and in the forefront of research on the effects of technology on privacy in our society, categorized the functions of privacy into 4 categories. The first is personal autonomy. Psychologists and sociologists have linked the development and maintenance of this sense of individuality to the human need for autonomy, the desire to avoid being manipulated or dominated wholly by others. Also, emotional release. Life in society generates such tensions for the individual that both physical and psychological health demand periods of privacy for various types of emotional release. You're going to also read about self-evaluation, which is one of these groupings or headings. And every individual needs to integrate his experiences into a meaningful pattern and to exert his individuality on events. To carry on such self-evaluation is essential. And then finally, Weston talked about the limited and protected communication, and the greatest threat to civilized social life would be a situation in which each individual is utterly candid in his communications with others, saying exactly what he knew or felt at all times. So we need to have some type of limited communication, not to say everything that we think at all times. Cell phone and privacy, you will also, in the Constitution, read about in this chapter. It's a very interesting chapter, as are the other chapters. Although the word privacy cannot be found in the Constitution, over the years, the Supreme Court has created 3 types of privacy rights through its interpretation of various constitutional amendments. The 4th Amendment protects against unreasonable search and seizure, and it protects the reasonable expectation of privacy on both the individuals and corporations against unreasonable and unwarranted government searches or seizures. While the 4th Amendment does protect citizens from unreasonable searches, it is triggered only when the government is conducting a search. So if you're dealing with a private corporation, there's no protection against unreasonable search and seizure under the Constitution. And while government employees might argue that electronic surveillance is a search in violation of the 4th Amendment, their constitutional rights are limited by a balancing test, and judges have to decide which weighs more, an employee's privacy interest or the need of the government or employer to conduct the search. Social media and ethics, you're going to read an excerpt by Anita Allen, professor of law and professor of philosophy at the University of Pennsylvania School of Law. And she addresses questions of information privacy and ethical responsibility in the excerpt. And the excerpt is titled An Ethical Duty to Protect One's Own Information Privacy. She characterizes the way people are giving away more and more personal data and intimate information to strangers as the great privacy giveaway. And in this excerpt, she argues that people ought to limit disclosures of information about oneself or personal information. Finally, Yale professor James Q. Whitman makes the distinction between conceptions of privacy in America versus Europe, and his quote makes this distinction. The American right to privacy still takes much of the form that it took in the 18th century. It is the right to freedom from intrusion by the state, especially in one's own home. The prime danger from the American point of view is that the home will be breached by government actors. American anxiety tends to be about maintaining a kind of private sovereignty within our own walls. In contrast, European privacy protections are at their core a form of protection of a right to respect and personal dignity. They are rights to one's image, name, and reputation, and to informational self-determination. The right to control the sorts of information disclosed about oneself. All rights to control your public image, to guarantee that people see you the way you want to be seen. They are, as it were, rights to be shielded against unwanted exposure, public exposure. Very distinctly from the U.S. perspective, the European notion of right to oblivion is the right to be forgotten. Privacy and genetic information. The Non-Discrimination Act of 2008, which has been referred to as, or is called the Genetic Information Act, or GINA. And again, it was enacted in 2008 to prevent discrimination on the basis of genetic information in health insurance and employment. Employees requiring fitness for duty or post-job offer medical examinations have the right to make certain that company doctors do not ask for DNA tests or family medical histories. It is advisable that all medical forms and questionnaires given by employers include prominently printed language that notifies individuals to not give us genetic information or family medical history. I hope that you enjoy Chapter 4. Let me know if you have any questions.